Yeah, good evening. Thank you so much for inviting me, particularly, of course, to Edge. And thanks to the law faculty of Bilkent who made this possible. And it's a great honor for me to speak here after 3 so distinguished colleagues in the framework of this lecture series Educative set up for the 100th anniversary of the Turkish Republic. But I really have to admit it's a bit frightening as well to be here as the 4th speaker for 3 reasons. First of all, it's a very impressive lineup. For example, Dieter Grimm is one of the capacities when it comes to constitutional law and constitutional courts, not only, particularly in Germany, but not only in Germany. So it's difficult to follow this lineup as such, but then what makes it more frightening still, I am the only non-lawyer of all these 4 speakers. And to make it worse, I have the most legal topics of all of them, you know? So they talked about, I don't know, Republic and whatever, so I'm talking about Constitutional Court. Then I'm the only one to speak about a Turkish constitutional institution, and this before a Turkish audience of experts. Anyhow, I'm starting to do it. And my only defense in this regard is, and this is what Ece Hoca just showed here, is this close collaboration we had over the last decade, one can say, and the outcome is this book on the Constitutional Court of Turkey between legal and political reasoning. And so what I'm going to briefly sketch out here is part of the analysis we did together with 2 other scholars from my chair over the last years. So the next 10 minutes, and here, you know, so this book, as you can see, it's quite a thick book, so about 700 pages. I still find it a bit difficult to really restrain myself, so if I'm too long, just please interrupt me before you fall asleep. The topic of my talk is the Constitutional Court of Turkey and the Principles of the Republic, a determined but not always helpful ally. ? I start by briefly explaining what non-lawyers like me find interesting about constitutional courts as such, and also why I am particularly interested in the Constitutional Court of Turkey and what I learned from this endeavor. Then I try to situate the Constitutional Court of Turkey within the history and the present of the Turkish Republic, and in a 3rd step I will give some very few examples of how the Constitutional Court of Turkey interpreted the Republican principles enshrined in Article 2 in its adjudication. And then I'll end with some concluding reflections about the quality of this constitutional institution as an ally of Turkish republicanism yesterday and today. Okay. So, why constitutional courts in social sciences? I'm a comparativist, as Ece Stipe just outlined, so I'm not an expert on Turkey as such. I'm an expert on comparative political system research, and here it's always important to understand, you know, so what are the patterns of particular institutions and why do they function this way or another in one context or another. And in general, in comparative politics, the idea is that so if, you know, comparative politics deals with constitutional courts as such, the standard operation procedure, so to speak, is to look at them as guardians of the constitution in established democracies. And then this can be problematic still, but then the assumption is that they are per se automatically, so to speak, defenders of rule of law principles and fundamental freedoms. But what if the system changes, or if it's not yet established as a democracy? And this is particularly where I'm interested in what constitutional courts can do. And then here we have very roughly summarizing it, two different theories. So, you know, political scientists always start with theories. And one is that constitutional courts are, you know, somehow like automatic promoters of democratic transition. So, and this was very much, you know, the current narrative, particularly in Eastern Europe after the end of socialist rule there. Constitutional courts were established in all these systems, and the idea was that they all will somehow, if not alone, but then at least they will be strongholds of democratic principles and enshrining democratic constitutionalism in these countries. After some years, we saw it's not always as easy as this. Let's look at Hungary, for example. So obviously, and Poland, hopefully there we will see some coming back of the judicial system as such. Anyhow, so this is a problematic model, I always thought. And then there's another theory which then is applied if there is no such thing as a democratic, you know, starting point or so. And this is what Ran Hirschl, a very influential political scientist and lawyer, he called this the hegemonic preservation theory, meaning that in countries where a ruling elite is about to lose power and to lose influence, they might create a constitutional court in order to uphold their influence, because it's sort of an counter-majoritarian institution. So even if the majority in parliament, for example, has different policy, so then this will be sort of the institution which will be helping the old elites to keep in power. And for a long time, and until today, one can say in many comparative, if there is comparative work about the Constitutional Court of Turkey, this is the very often applied idea, so that the Constitutional Court of Turkey was, and still is, question mark, sort of the guardian of one particular elite in order to uphold their principles. And at some point this was called the principles of the Republican Alliance, so Kemalist elites somehow, but then this is also very questionable theory as such. And then in Turkey, after more than 60 years, so it's somehow absolutely not realistic to still think there is this one elite, and this was, and then as the book very well shows, it was never such a homogeneous elite which somehow was and the Constitutional Court was the representative of this elite. So this was never true. This is some of the outcomes, or one of the outcomes of our study here. And somehow we started out when wanting to somehow test or try to work a bit against these general ideas. In a way, so the Constitutional Court of Turkey is a model object to study. It exists for a very long time. It's one of the oldest constitutional courts in Europe. And then it has substantial competences, and it functions for a long, or has been functioning for a long time in a political system which is somehow in limbo between more democratic and more autocratic phases. Starting with all the military coups, and then also over the last 20 years. So this is something where we can always see this in-between situation, as Stepe just said, so the gray zone, which is something which is important here. And therefore, I think one can very well ask or answer, hopefully, the question, or the questions we wanted to answer is, what role did and does the Constitutional Court of Turkey play in this political system in limbo, and why? And also then, in a broader sense, what can we learn from this outcome for other constitutional courts? I will restrain myself to the Turkish part this evening. Perhaps in the discussion we can, if you are interested, we can somehow expand beyond Turkey. Okay, so very briefly on the historical mission of the Constitutional Court of Turkey as a defender of the Turkish Republic. As you all know, the Constitutional Court came into being in May 1962. as a result of the military coup of May 1960 and the following constitution-making process. And its creation was directly linked to the dispute about what the Turkish Republic, founded by Ataturk, meant and how it should be protected. In a way, this question is at stake until the present day, and perhaps it's even more urgent today. And I will refer, speaking about the principles of the Republic, as enshrined in Article 2 of the current situation. I will come to this in a moment in more detail. For now, the Republic is broadly, so I'm going to define the Republic or the Republican principles broadly as a constitutional order based on principles of rule of law and the guarantee of fundamental rights and freedoms. So the details will come in a minute, but this is sort of the starting point. And one can see that since the 1950s, there was a fierce struggle within the Turkish political system of what this Republican order should look like and how it should be defended. There was this problem of unconstitutional laws by a parliamentary majority, and then, you know, the opposition, and then the problem, there was no possible regulation or no review institution who somehow could protect the constitution against this. And therefore, in 1961, the Constituent Assembly, dominated by CHP influence, had this idea of an institutionalized and independent judicial control mechanism, and it definitely aimed at forcing any parliamentary majority to respect the Constitution in the future. And in hindsight, the Constitution of 1961 can be characterized as by its basic distrust in popularly elected political structures, and therefore it introduced this powerful constitutional court as one of the mechanisms by which the then ruling elites intended to prevent the consequences of unchecked majoritarian democracy, hence hegemonic preservation theory, Ryan Hirschel at its best. So at the beginning, I would say, we say in the book, yes, this was definitely the case, but the question is, what came then? As you all know, there were repeated substantial constitutional amendments to the competences and the functioning of the Constitutional Court, and it started early on, already in 1971, so 10 years after the court had come into existence. There were two major changes. So the military, after the coup of 1971, forced two changes in terms of the competences of the court, and one important reason, and the first one was that that constitutional amendments could only be reviewed according to their form and not in substance. So in the first 10 years of its existence, so the court had happily engaged in also, you know, in substance controlling laws in terms of which were meant to change the constitution. And so the military wanted to put a stop to this. And particularly in 1970, there had been a ruling where the court had insisted on it has to review also constitutional laws, not only in form but also regarding to substance, because it is not only in the ruling there was this passage where they said. They made it very clear that it considered parliamentary majorities not only bound by the formal requirements of legislation and constitutional changes, but also by the spirit of the Constitution, so the overall idea behind it, closely linked then to the idea of republicanism. But still, it didn't work because there was this reform, but the Constitutional Court went on because they said it's about the spirit of the Constitution to control or to review laws, constitutional laws in substance as well. We will see how this ended. The second thing which was changed in 1972 was the range of applicants, which was restricted, and there also was a very political reason to this, because in the first years of the Constitutional Court's existence, it was particularly one small leftist party, the Turkish Workers' Party, which between 63 and 71 had submitted 40 abstract non-control review proceedings in order to somehow democratize not only the constitutional order but also the legislation behind it. And this is a remarkable number if one keeps in mind that this was only in the first years it was only one member of parliament from the Workers' Party, and then for some years it was 15. But anyhow, so the ruling elites and the bigger parties were not very amused that there was this, this very progressist way of making use of the Constitutional Court in a way, and therefore in 71 the number of deputies who were allowed to appeal to the court were put up to 10. So from then on, the Workers' Party was out of the game in a way. As you know, in 82, there was the new constitution after a renewed military coup, and this constitution reflected the military's mistrust of the people's will even more openly than the one of 1961. Elected assemblies, political parties, and all civil society institutions, trade unions and such were weakened, and the competences and the areas of action of the Constitutional Court, as well as the range of possible applicants, was further restricted. And most importantly, this idea that constitutional changes can only be revised in a formal way, or on its formal, so that this is only a formal review and not to substance. This was introduced in the new constitution, and since it's a big issue, and I'm not going to elaborate on this, but if you want, we can do this in the discussion. One says that at some point during the constitution giving of 82, even the very existence of the Constitutional Court was at stake, but in the end, the Constitutional Court survived as an institution. The last reform I want to mention was in 2010, and so this also, again, political background. When the AKP won the elections in 2002 for the first time in Turkey, there was a right-wing Islamic party in a single-party government, and this led very, very rapidly to intense tensions between the Constitutional Court and this government, and so the court was involved in several political conflicts, for example, over the election of the President of the Republic, also over the question of headscarves, of the question of headscarf ban. I'll come to this in a minute. And also, as you certainly remember, there was this very narrow question of prohibiting the AKP as such. So this was sort of a very tense political time. And one can say that the constitutional reform of 2010 can be understood as the AKP's response to this ongoing constitutional crisis. However, it was not only, it was not only a restrictive reform in a way, but also it brought about the fundamental change, introducing the individual complaint proceedings, which somehow fundamentally changed the work and the role of the court. I'm not going into detail here as well. What we can see from this brief historical summary is that the court not only had repeatedly to adapt to substantial changes of the constitutional and legal basis of its work, but as well it has to adapt to fundamental changes of the political context. And in retrospect, one can state that the court stood its ground despite these changing constitutional and political environment conditions. Very roughly, one can say that in the 1960s and 70s, it contributed significantly to establishing the Turkish state under the rule of law and to promote, at least in some regards, fundamental rights. So hence, so these ideas to cut it down a bit. And then since, under the new constitution since 1982, it succeeded in partly reining in the executive branch by, among other things, regaining judicial control over executive lawmaking. One term here is the control over emergency decrees as well, something which is also very important these days. But for a time, this worked quite well. And then in a series of decisions in the 1990s, the court also defined the standards and the implementation framework of basic fundamental principles of the rule of law, and also some freedoms, for example, gender equality. There are some very landmark decisions in a very progressive way. There are others, I'll come to this. But all in all, one can state that the growing institutional self-assurance of the institution and the gradual promotion of the fundamental values and liberal as a result, the court in the 90s somehow had an important role in promoting fundamental values and liberal constitutional democratic principles. And not least, the introduction of the individual complaint played a big role here, at least until the state of emergency was introduced in 2016. Now comes the however. Some abrupt changes in the adjudication, oftentimes incoherent decisions. I will go into this in a moment, and this is why the end or the summary of the first part, yes, it was an ally of the Turkish Republic in terms of democratic and progressive understanding of republicanism, but not very reliable as an ally. And I want to give I have some time to do this, some examples why this is so problematic, and in order to understand why this is so problematic and why the overall picture is not, so black or white, one has to go a bit deeper into detail in the argumentation of the rulings. And here, starting again, I would go more into detail about what are these Republican principles enshrined in Article 2 of the Constitution of 1982. It was very similar before as well. So there are these characteristics of republic. Say that Turkey is a democratic, laicist, and social state governed by the rule of law within the notions of public peace, national solidarity and justice, respecting human rights, loyal to nationalism of Atatürk, based on the fundamental tenets set forth in the preamble. So we have a lot of principles already, and then we have the preamble, and one can say, so general principles for constitutional democracy, this is what I started with, but there are some peculiarities, and some of these peculiarities can be, are further spelled out in the principle of Atatürkism listed in the preamble, so which is then referred to in Article 2. Here particularly, the concepts of laicism and nationalism are somehow problematic. Laicism in this context does not mean a mere separation of state and religion or a strict neutrality of the state towards all religions. Instead, the Turkish state controls religions, in the plural, primarily in order to fend off a particular form of traditional anti-modern Islam. I'm not going into this in more detail because I think that Stéphanie Hennet-Vaucher talked about laïcité in the French context, and then you certainly also compared it in a way to what's the similarities and the differences in Turkey. But then the other principle, which is mentioned in the preamble and then which is referred to in Article 2, is nationalism. And here, one can say that Turkish constitutionalism as such is obsessed with the protection of the territorial and national integrity of the state against all sorts of enemies, external as well as internal. And one Turkish as one Turkish law professor once put it, and this fixation on an imagined homogeneous nation also led to the elevation of Turkishness above all other ethnic and or religious identities in the country. So these are by itself principles which make it difficult, so these are Republican principles as well, and so somehow for the Constitutional Court, it has to maneuver in a way with these particular understandings which are set from the start. One can say so that the Republican principles are somehow a mixed bag, containing liberal and democratic elements as well as more etatist or even authoritarian aspects. And it is against this backdrop that the Constitutional Court had to interpret the Republican principles in its rulings. And in this situation, there are two options, one can say. So, in the abstract, one can either employ the principles in general only as merely the rhetorical device, or one can try to build concrete decisions on them in an operative manner and somehow also triggering specific legal consequences from it. The problem is that in the rulings of the Constitutional Court of Turkey, and we analyzed quite a lot of them in our book, we found ample evidence for both approaches, so which is a bit, somehow contradictory in itself. First of all, we can state that the Constitutional Court frequently refer to the preamble and the Part 1 of the Constitution, so meaning the Republican principles, instead of the more concrete constitution provisions, for example, so the second section of the Constitution where you have the same principles, for example, equality before the law, and others, again, in a much more concrete way. So this is already a choice that you, in the rulings, you somehow put the emphasis more on the principle side and not so much on the concrete provisions side. And then also the purpose of these references to the principles differs from ruling to ruling. Sometimes the general concepts are translated into concrete operative provisions, and sometimes they stay purely abstract and rhetorical. Some of the examples I will try to show what I mean by this. Of course, it's not possible to do justice to the adjudication of this court in just a few minutes, but for this, of course, then you have to read the book. So what we found is the most frequently employed principles are the terms public order, which is not in the wording of Article 2, but somehow it's also, so deducted from there. Nationalism, laicism, rule of law, and equality before the law. And in addition, we also found very often references to the principles of civilization, and which is something which is not as such mentioned in the Constitution, but also deducted then from there, and moral values like peace of the family or honor as such. These are also regularly invoked principles in the rulings. Other principles which are also in these principles of the Republic of Article 2, such as social justice, so we just had, so I enumerated them, so there was the social state as well, or also democracy, which is also enshrined in Article 5 again, are mentioned significantly less in the rulings, so this is already one statement. And then among the principles directly deducted from the Constitution, rule of law and equality before the law stand out because these are the only ones where the court has, so to speak, standing definitions which come in each and every ruling. For the rule of law, it is, and I quote, Turkey is a state under the rule of law which respects and protects human rights, which establishes and carries out an equitable legal order, which is loyal to legal norms and the Constitution and all the acts which are subject to judicial review. This is a definition which is employed again and again, and here in particular, the importance of judicial independence and, hardly surprising, of independent judicial review are underlined on many occasions. So this is the most concrete you get out of this rule of law principle. And while binding legal consequences are deducted, particularly from this judicial review part and in some of the key decisions, we analyzed, and also when it comes to restricting administrative acts for the sake of the legislative supremacy of parliament against the executive, here then the rule of law idea is translated into very specific obligations of the legislator and the executive. In other cases, the term remains rather detached from any concrete understanding, and just, is quoted as a principle, but then there's no consequences. The same holds true for the principle of equality. Here again, we have a standard definition which is evoked each and every time there is equality before the law as one of the evoked provisions. And it runs as follows. Equality before the law principle does not mean that the same legal rules should be applied to everyone in all aspects. Applying different legal rules to some citizens does not violate the equality principle if they are based upon a rightful reason. The Constitution aims at legal, not de facto equality. Okay, as far as it goes, but then the consequences drawn from this distinction between de jure and de facto equality differ significantly from case to case. And here I want to show you and quote from one of the, from some of the rulings we analyzed. To start with a very sort of a very good example, where a very systematic and operative way of applying equality can be found in the court's first ruling on equal treatment of spouses in case of adultery, which was rendered in 1996, I think. The merits of this ruling very precisely distinguish between constitutional and unconstitutional forms of discrimination between wife and husband. And while unequal treatment, so treating unequal things differently, while unequal treatment of different sexes may well be justifiable, according to the court, in order to protect women because of a distinction required by nature and functional properties, it does violate the principle, so Article 10 principle of equality before the law, if the distinction is used to privilege men. And from there, then they come up with a very detailed and very systematic definition and understanding why this particular law was unconstitutional, because it somehow violated this idea, because this idea of men and women being different was somehow too broadly applied to the particular problem at hand. Other key decisions on very similar issues refer to the principle of equality only in the abstract, giving no substantiated reason for the particular interpretation of the constitutional principle. This purely rhetorical use mostly occurs when the court found that other, less well-defined general principles are in conflict with the equality claim. Above all, the very broad understanding of public order, and this was one of the other principles, often prevails over the principle of equality. The example I want to give here are two decisions on the right of female spouses to use their premarital family name. In parentheses, this case and the next case were then afterwards, solved by individual complaint decisions. So this is why I mentioned this in the beginning. So this really changed the role of the court, but I'm not going into detail here, just to keep this in mind. So the rulings I'm speaking of stem from 1997 and 2011, so more than 10 years apart, more or less 15 years apart. And despite the fact that this was two different generations of justices within two different political settings, the majority of the justices not only came to the same result, but it also based its decision on a very similar form of constitutional reasoning. According to both decisions, the Turkish law on family names that forced married couples to exclusively use the husband's name as the common family name does not violate the wife's right to equal treatment. Why? In the first family name decision, the standard definition of the principle of equality was not at all connected to the concrete question of family names. Instead, the merits laconically state that rightful reasons might prevail over the female spouse's claim to hand down her premarital name to future generations. And these rightful reasons were spelled out briefly then, and it reads as following. By inheritance of the family name from generation to generation, unity and integrity of a family will endure. The legislator has given priority to one of the spouses so as to enable the unity of the family. Public interest, public order, and some necessities, that's it, nothing about what these necessities might be, prove that it is rather preferred that the surname should be conveyed by the man. So in a way, we have the principle of equality in the beginning. It's stated, yes, different things can be treated differently, similar things should be treated similar, and then comes anything about, I don't know, some necessities or the unity of the family. Fine, but so why can't the unity be somehow guaranteed if then it's the other name? Anyhow, there might be, you might find any reasons to justify this, but they don't. This is the main point. It's just these very lofty ideas of some necessities. And this is exactly what 3 dissenting opinions to this decision explicitly criticized. That the majority only refer to these abstract concepts instead of substantiated legal argumentation. And then in the second family name, more than 10 years later, same story again. They elaborated a bit more on what these necessities might be, but very, very technically, public order requirements, keeping civil registration records properly, preventing any confusion in official documents. This was it, and this was just, somehow juxtaposed to the idea of equality before the law, which is certainly not very convincing. Independently of what you think, it's not about what is right or wrong here, it's just about how it was argumented. This example illustrates the concept of public order is not only particularly dominant in Turkish constitutional adjudication, but it is also applied in an extremely broad and imprecise manner. Necessities. In contrast to the standard definitions of rule of law and equality, the Constitutional Court never even developed a standard definition of what public order might be. Instead, the term can take many meanings, and it can be conveniently justify almost any argument brought before the court if it seems appropriate. Laicism and nationalism, yeah, I think I should, I don't know. Can I have one more example? 5 more minutes? Okay. So in the 2 other principles I mentioned earlier are laicism and nationalism. And here the first headscarf decision rendered in 1989, so before AKP times, stands out because it offered particularly detailed definitions of both concepts. Yeah. So I read one paragraph of the ruling. Laicism is a civilized lifestyle which, by destroying medieval dogmatism, forms the basis of the concept of freedom and democracy, nation state building, independence, national sovereignty, and the ideal of humanity, which developed with the supremacy of reason and enlightenment of science. So very broad concepts, So. And this is, so this is even more than republicanism as such. It goes back to the Enlightenment and everything to say this is what stands against the idea of religious symbols, of wearing religious symbols in public. Some paragraphs later, they give a similarly detailed account of nationalism, and it's Atatürk's nationalism, which marches as appropriate for and in accordance with civilized nations on the path of development and progress and in international proceedings and relations, is that form of Turkish nationalism which covers everybody who is happy to be a Turk. According to this definition, among the elements that constitute the nation are common language, national feeling, and feelings of kindness, unity in political existence, a common fatherland, common roots, a historical and ethnic closeness. So here, somehow everything is put together and amalgamated in order to just argue against one precise and particular constitutional question, whether the also enshrined freedom of religion covers the wearing of headscarves in public, and particularly in higher education institutions. Both quotes are excellent examples of the crucial importance of such highly abstract key concepts and also morally loaded key concepts Similar, if shorter references to the characteristics of republics can be found in many other analyzed rulings. The quotes also illustrate how the justices' understanding of the principles of nationalism and laicism amalgamate into one single holistic interpretation of the constitutional foundations of state and society in Turkey as such at large. In a broader sense, these national values represent progress as such, which is defined as the ideal of humanity which developed with the supremacy of reason and enlightenment of science. So this is somehow the problem here, is that you have perhaps very well intentions, but then the way of how these intentions are translated into real and hard constitution court decisions gives way or opens way to all sorts of moral argumentations and somehow renders other constitutional principles which are also enshrined, like, for example, in this case, freedom of religion, somehow obsolete. And this wouldn't have been necessary. That's the point, you know? So you could have done this in a much more pragmatic and what I called operative way, in somehow transferring these lofty principles into something concrete and in something comparable as well, and then sticking to it. Very briefly, some concluding remarks. So these examples from the key rulings highlight the fundamental ambiguity of the court's reasoning, oftentimes juxtaposing irreconcilable constitutional concepts and moral values. This is, as shown, partly due to the ambiguous character of the constitutional text itself. So already we have the problem that in these republican principles we have this nationalism, for example. But as some of the rulings we analyzed clearly show, the court definitely did foster a liberal and democratic understanding of the Constitution as such, and of Article 2 in particular, in some of its rulings. And then it abandoned this clear course in other rulings, often without a direct political background to explain this change. As a result, the court never succeeded in developing a coherent and consistent interpretation of the republican values of the Turkish constitution, which could have set the standard for Turkish education in general, not only constitutional, but also other education, and at some point, hopefully, even new legislation. It is against the backdrop of, against this backdrop that I would conclude, or better, eduge stepe, and we concluded in the book, that the Constitutional Court of Turkey at times proved to be a very empathetic and energetic ally of democratic progressive understanding of Turkish republicanism, but that this support was not always reliable. One explanation certainly is the unstable and politically oftentimes difficult environment I referred to several times. In this regard, the years since 2016 are particularly trying, for sure, but outside threat to the court's independence or even to its mere existence are nothing completely new. In this regard, the assault of the Court of Cassation against the Constitutional Court, which we had to witness recently, is only one more example of a long row of problems. But this difficult and unstable political context can only explain part of the problem. As I tried to show in this presentation, much has to do with a lack of clarity and coherence in the adjudication. This, at least, is something the court could mend independently of any political climate. And last sentence, perhaps this would have even helped then if there are rough political times. It's much better if you have something you can fall back on and say, but this is our standing interpretation of a certain principle, and we have, you know, sort of an established adjudication here. Then it's much more difficult for the executive or whoever wants to somehow disturb these defenders of republicanism to then argue against this. Then if you have a situation where from the start there is no clear-cut line in the adjudication visible or traceable. Thank you so much for your patience.
Thank you very much, Silvia. We have time for discussion. If you have any questions. Yeah. Okay.
Hi. Thank you, Madam, and welcome. I'm wondering why the Supreme Court
Continue.
Does this ambiguous stance, I agree it would be so much easier with the executive branch and also, but why?
That's the $5 million question in a way. So, and I already said, so it's very difficult to really, so there are certainly, there's not one reason. And there's not one single reason. There are several reasons. And I think one certainly is that it is difficult if you have to render your rulings under these very, volatile and unpredictable circumstances at some time. Sometimes it's perhaps even very reasonable to try to keep a low profile in order to save the institution as such from being abolished or being somehow punished in different ways. In a non-established democratic environment, for sure. But then we also found, and I didn't speak about this so much, or not at all, so we also find that the way how the decisions are made in a way is somehow incoherent in itself. So the institutional process, the internal institutional process, in general, one could say it's a process which aims at deliberation and compromise, and the judges are supposed to come together to one conclusion, and there are repeated readings before the ruling is rendered. But at the same time, there are no incentives to really somehow compromise, and it is a common habit that, and you are even forced to give your consenting opinion on each and every occasion, not only in the end, but even so along the way of finding or writing a decision. So even if there are several provisions at stake or something, then there is the count of votes in a way in each and every paragraph. And so you have this already, so a very, very incoherent picture, and this gives the impression that anyhow there is not one consensual ruling in the end, but there is sort of a group of judges who obviously don't even aim at, or at least are not able to come to a final decisive conclusion. And what we found, so it's difficult to prove this really, in political science terms where you really want to have hard empirical proof, but what we could show is that the more politically loaded a subject is, the more incoherent and problematic the decision-making process becomes as well. Yeah, and then so there is some, perhaps not causality, but there is some probability that this is also linked to the politicization of some issues. But it's not always the case. We also found decisions which are not as politicized, and then, for example, there's and sometimes it's the other way around. For example, that we analyzed one ruling where on the definition of terrorism, and the ruling is very, in a way, restrictive, and this is a very broad way of defining what terrorism can be and who can be punished for it. But at the same time, the way how it is rendered is very systematic and coherent. So even, the other way around, it's not always the case. So therefore, it's so difficult to say this is the explanation for it. Yeah. So there are different problems at the same time.
Thanks for the great lecture. I just actually had a different question in mind, but if I'm allowed to ask more than one question, perhaps I could begin with something more fundamental, which goes to the earlier question, actually. How do we distinguish between the legal and the political? Or how do you distinguish? Because let me play the devil's advocate here and say in some of the decisions that you cited from the 82 Constitution period about secularism, it is true that the court delves into more philosophical issues, and there are statements which would perhaps be more suited to a theoretical philosophical paper about what secularism is. But then again, it also shows that the decision itself is actually quite sophisticated, and although you might not agree with the normative implications of what is being stated by the court in those decisions, they do nevertheless demonstrate a certain level of detail. And again, we might not agree with court's characterization in those decisions of secularism, but it might also be argued that the court, and considering the fact that the court has been quite consistent on this issue, some of the statements that the court uses in the HDU period are just quotations from its earlier jurisprudence in 61 constitution era. So, yeah, I guess the question is, how do you distinguish the legal from the political? And the second question is more concrete. You suggested that the hegemonic preservation theory seems to be explicative about the establishment of the court, not necessarily what came after, but the establishment of the court. I guess I'm not convinced by that argument, because on the one hand there seems to be a conceptual issue. Things like a certain modicum of distrust against parliamentary majorities, or granting autonomy to certain public institutions like universities or state broadcast. These are elements of constitutionalism itself, particularly constitutional review. You know, it is inherent in the idea of constitutional review that the word of the elected is not necessarily the last in a constitutional democracy. And I just wonder whether certain concepts that are we too quick to assume that the Turkish version of constitutionalism is sort of it can be characterized under the hegemonic preservation theory, rather than being genuine instances of these general concepts that we find in instances of constitutionalism around the globe, in pretty much everywhere. And there is also a certain background to the establishment of the Constitutional Court. There was an attempt to institute such a court even back in the Ottoman period. And then it was followed in the 20s by certain intellectuals like Ziya Gökalp, who were very important to the regime at the time. They suggested the establishment of the institution. Throughout 40s and 50s, the minority parties, not the majority ones, demanded a constitutional court in various different occasions, and the demands were not just of the RPP, but also of other political parties in the opposition who were usually, they were traditionally at the right side of the spectrum. Yeah. So I was just wondering, why do you think that that the hegemonic theory seems to explain the establishment, given that on the one hand these concepts are more or less universal for legal constitutionalism, and on the other there were actually quite a lot of attempts before, even before this idea of Republican alliance came to be. Mm-hmm.
Yeah, great question. So I start with the distinction between political and legal argumentation, or as in a book which we used a lot, it's called constitutional reasoning more. Of course, this is just to juxtapose it. This is particularly when we talk about constitutional courts, doesn't make sense, because the matter on which the decisions are given are political as such. So there is always partial political side to it, for sure. And then the constitutional principles, even if it's not as broad and as maybe problematic as in Article 2 of the Turkish constitution. It's always principles, and it's always somehow has to be concretized, and so on and so on. Yes, of course. Two things. First is that from my perspective as a non-lawyer, I criticize most of the non-legal literature on constitutional courts, that they just assume it's only political, and they even don't read the decisions and the argumentation. They just count whether it was for or against, so whether the government was somehow supported or contradicted, something like this. Exactly. And this doesn't make sense either. So obviously there are two sides to it, and you have to go into the argumentation, and above all, it's a judicial institution, and it functions differently from political actors or political institutions, and therefore also this idea of ex post justification of the decision is something which you should take seriously. And there is quite an emerging literature on this. Then you can, if you look beyond a very, very narrow dogmatic way of reading these rulings, you can come up with some indicators or some categories where you can say, okay, look here, this is, at least there is a clear link to legal principles. They quote, norms, and they somehow try to use normative logic in arguing. And then there are phrases, and I think I read some of them, where it's completely unconnected to any sort of legal reasoning. And then you can quite, I think it's quite legitimate to then assume here we have a political way of trying to make a point. And exactly, so the headscarf ruling is the first headscarf, and I think all the headscarf rulings in a way are very good examples for that, so there might be a way of how you can deal with this problem in a mostly, let's say, legal way, constitutional legal way, by saying, look, it's the constitution, we have these restrictions, we have this principle of laicism, and if we look at the spirit of the constitution, and then it becomes already a bit lofty, but so you could still stay in this argumentative, somehow line, then you could come to the same outcome. And I think this is what you had in mind, saying there are parts of this ruling where this is done. But then somehow this effect is spoiled by having these other parts which are so obviously, the outcome of even a legal dispute, a political dispute on the bench, so. And this is something which then somehow undermines the legitimacy of this mainly legal or, non-political institution. Having said this, I think this is also very important if it comes to these, constitutional courts in the gray zone, because pretending to be 100 or even 150% legal and not political at all can be a very good way of keeping your distance and keeping your independence in a way, and saying, okay, so this is, I'm not meddling with politics at all, and or we are not meddling, so we are really, this is just the constitution. It's not us, it's the constitution, and somehow you can somehow depoliticize some very, very disputed matters in this way, and this then can help the court and can also help foster constitutionalism as such. And so therefore I think this is also important. It's not only an academic endeavor to somehow distinguish between these two trends, and I absolutely consent that there always will be both, but it's also of practical value, in particular in a situation such as the Constitutional Court. In parentheses, as we see now, even courts which for, I don't know, decades thought to live in a 100% safe democratic environment might wake up one day and find, okay, perhaps it's good to remember that we are first and foremost legal institutions and not political ones. Okay, so this was the long answer to a long question to the first question. Second question, I try to be brief here, the hegemonic preservation theory. I think there is a difference between what this hegemonic preservation theory stipulates and what you meant when you said, yeah, but in a way, constitutional courts as such are counter-majoritarian institutions. This is true, and this is their value. So, and this is a decision which the society makes, saying, obviously, we want to enshrine some principles which are then out of day-to-day political dispute, and therefore we want to have a constitution, and we want to somehow give us this meta framework, and then also we want to have a guardian of this meta framework. And even those who are elected are not automatically authorized to do whatever they want in terms of playing around with these rules. Martin Lavlin was here before me. Probably he would have a bit different approach towards this, yeah? But I think if you believe in the sense of constitutional courts as such, then you have somehow to also buy this idea of there is something which should be out of the political day-to-day dispute, and then of course it makes sense to say this is a particular also, or part of it particular is that democracy is more than majority rule. And it's particular the minority positions and the weak positions in society as well, which need this protection by a constitutional court sometimes, yeah? But this is not what Hirschl means when he speaks about this hegemonic preservation thing, because here it's a very political approach, saying it's not that you want to, you know, for all times you want somehow to safeguard some common principles, and then if at some day the society changes the idea about these principles, then one could even then we have to have a new constitution, and then we start again. But until then, these principles are out of you know, the political dispute. It's not that. What he says, or what he means, is that it might be a political instrument. So creating a constitutional court might be a political instrument to just prevent and somehow destructively counteract normal political decision-making by the majority, by saying, but this is then unconstitutional, and, you know, so somehow trying to maximize the amount of norms and principles which are out of political, you know, were taken out of the political domain. And this is something which is definitely then undemocratic in a way, because it's not protecting democracy by having parts of it somehow enshrined. It's then making democracy impossible by hindering majoritarian decision-making and political change, and this is the thing. And therefore, I would say, okay, if you have the theory, then partially at least it's applicable to the early years of the Constitutional Court in Turkey, but since the Constitutional Court of Turkey evolved, the society evolved, changed dramatically, and therefore it's just not a good explanation to stick with. And we were really amazed also when we did our literature review in a way, so that almost each and every article which at all deals with the Constitutional Court somehow quotes this until today, the thesis. After
it's kind of the standard picture.
Yeah, exactly. And this after more than 20 years, yeah.
Even before Hirschl, the idea of elite control
exactly.
has been
Yeah.
In the Turkish since 50s.
Absolutely. But then, you know, so last 20 years are somehow, you know, so this is the idea, or the whole idea was that then now the anti-elite, if such a thing ever existed, so I'm very skeptical about this, but then at least then, you know, so one would say now it's the anti-elite which somehow came to power, and then still they are part of this Republican alliance, so sorry, I just don't buy it. We somehow tired everyone out.
If you would like to come with us, we will go to Niches to drink and eat and talk further about other things. And thank you very, very much for of them are face-to-face. Thank you very much.
Vielen Dank. Schade